So a labor peace agreement, in case you're not familiar with the concept, if, for example, if a private individual or entity is involved in a construction project, say I'm building a mall, and I want to make sure that my construction project goes on without interruption due to labor issues, I can require my contractors to enter into labor peace agreements with the union to ensure that there won't be such interruptions as a condition of them becoming one of my subcontractors. Governmental entities can do so as well when it is a project that where they're purchasing goods or services for itself. Say, Los Angeles wanted to resurface the runways at their airport, and they wanted to hire companies to work on that. They could enter into labor peace agreement, or require their subcontractors to enter into labor peace agreements. What we're getting to now here, though, is something more akin to regulation, which is what governmental entities cannot do. They cannot regulate when it comes to certain aspects of the labor management relationship. That's the Garment and machinist doctrines that developed initially into the NLRA, but also have been applied to the Railway Labor Act. So the issue in this case, and others like it, are where's the line between government regulation and market participation? So in LA, the Los Angeles Airport Authority, LAWA, has a certified service provider licensing program where if you want to be a service provider to the carriers that are operating there, you have to agree and enter into and sign this CSPLA. And it has various provisions in it of all sorts. Last time they revised this, they added, for the first time at the behest of the SEIU, a labor harmony, what they call labor harmony obligation that is intended, it said, to ensure that the service provider's employees can work in labor harmony. One of the things it requires that if there's any organization, and that's not necessarily limited to a formal union, but any organization whose purpose is to advocate on behalf of employee benefits, wages, et cetera, at the airport and its service employees, asks for a labor peace agreement, the service provider has to engage in a process and enter into such a labor harmony agreement with the organization that so demands it. The labor harmony must include a binding and enforceable provision that bars the organization and its members from picketing, striking, boycotts, etc. And that's where the rubber hits the road in these cases. The airport is saying we need this so we can ensure smooth service at the airports. If the parties are unable to voluntarily negotiate a labor harmony agreement, it then goes to mediation. If that fails, there's an arbitration process where an arbitrator could end up imposing the terms of the LPA.